This is part two of the lecture on dispute resolutions discussing mediation and due process hearings. My name is Dr. George Giuliani from Hofstra University, and we left off part one by discussing uh, the whole concept of what happens when parents and school districts cannot agree and parents filing a due process complaint. We talked about calling for another IEP meeting. We talked about mediation. But if those IEP meetings or resolution meetings in terms of mediation, if none of that works, we then have to go to a more formal process, a legal hearing in the manner known as a due process hearing, an impartial due process hearing. So we try to resolve issues between parents and school districts before going to the formal due process hearing. But if resolution meetings or mediation doesn't resolve the issue, then we move to due process hearing. Now, the State Department of Education, known as the State Education Authority in New York, we call it the New York State Department of Education, it's required under the federal law to provide impartial hearings to resolve disputes arising over the free, appropriate public education of children. So when we talk about an impartial hearing, impartial means not favoring one side or opinion more than another. So an impartial hearing officer is a non-biased, fair, and doesn't favor either party person. So an impartial hearing officer is going to be non-biased, fair, and doesn't favor either party. The state education department, the New York State Department of Ed, if you're from New York, okay, has people who will be the hearing officers. So they don't work for the school districts. They're not known by the parents. And we have an impartial hearing. It's literally going to be a legal hearing on the matter. An idea is very detailed in describing the nature of the required hearing. An impartial due process hearing is a formal process. It's a formal legal process to resolve a dispute between a school district and the parent. The dispute may concern a recommendation regarding the identification, evaluation, placement, or the provision of a free, appropriate public education for a child. And this due process hearing will be conducted by an impartial hearing officer, an IHO, certified by the New York State Department of Ed, certified by the Commissioner of Education in the state, and regularly trained in special ed law and regulations. And the decision by the impartial hearing officer regarding this dispute is legally binding for all involved. So whatever the hearing officer says or rules on, that is the decision. So again, we're going to a trial in a sense. We're going to a mini trial between the parents and the school districts to discuss a dispute on some type of issue pertaining to the child's identification, evaluation, placement, or his provision or her provision of a free, appropriate public education. And it will be in front of an impartial hearing officer. Think of a judge. This is our judge, our impartial hearing officer, and the decision made by the impartial hearing officer, or the IHO, is legally binding for everybody involved. Now, one thing to note is that prior to the impartial due process hearing, at least 5 business days prior to that hearing, each party has to disclose to all the other parties all the evaluations of the child completed by that date and all recommendations that the party intends to use at the hearing. So at least 5 business days prior to the hearing, each side has to show the other side, this is who we're going to be presenting, these are the reports that are going to be used, this is what's going to be coming at the hearing. Everything's got to be submitted to each party. And if a hearing officer finds out that the parties don't do that, the hearing officer can bar any party that fails to comply with this requirement from introducing any kind of evaluation or recommendation at the hearing without the consent of the other party. What we're talking about here is there's no surprise here. Okay, you can't come to the hearing and say, oh, and here's a report that I just received, and the other side doesn't have an opportunity to review the report. You can't walk into a hearing and go, oh, I'm going to present this particular witness, or I'm going to present this particular person who will discuss a particular report when the other side hasn't had a chance to look at that information. So the law is very clear. At least 5 business days prior to the hearing, both parties have to disclose to all other parties the evaluations of the child completed by that date and any recommendations that the party intends to use at the hearing. And again, if you don't do that, the hearing officer can bar that information from ever entering into evidence. So, the impartial hearing officer presides at the hearing and provides all parties an opportunity to present witnesses and testimony. The hearing is recorded, or a stenographer is used to take word-for-word notes of the hearing. I mean, think of a trial. This is very much what a trial is without the jury. Okay, we've got a judge and we've got two sides. Each side is going to present his or her arguments. And arguments and evidence of both the parents and the school districts are presented before the impartial hearing officer, who will make a decision on the matters at issue. And each party, in general, each party has up to 1 day to present its case unless the hearing officer decides more time is needed. So in general, unless there's some reason why not, each party will have 1 day to present its case. So the school district will have 1 day to present its case. The parents will have 1 day to present its case. It may all be finished in 1 day in total. It might need more time if the hearing officer determines that. And either party may be represented by an attorney or may present their cases themselves. I will tell you that going to a due process hearing without an attorney is probably not a very good idea, because it is a legal hearing. And if the parents come in without an attorney and the school district comes with an attorney, it really gives the school district a tremendous advantage at the hearing. And the procedures and the requirements for a due process hearing depend on state laws. So how a due process hearing is run in New York might be different than how it's run in Wisconsin, which may be how it's different in California. So how the impartial hearing officer runs the hearing can vary from state to state. But again, either party, no matter where you are, may be represented by an attorney or can present the case themselves. So what happens? Each party presents its case. Each party represents, their side of the situation. And then once both parties are done, the hearing officer, the impartial hearing officer, will then make a decision. The impartial hearing officer will write a finding of fact and a decision based on the evidence. All right. So a decision will be rendered by the hearing officer after both sides present their case at some point, and it will come as either a written or an electronic record of the hearing, findings of facts, and decisions. So the parents will find out, the school district will find out as a written record. The hearing officer will write up his or her decision. Now remember, the decision by the hearing officer is the final decision. That's it. It is legally binding. That is it. So the decision made by the impartial hearing officer is final, unless the parent or the school district asks for a review of the decision by the state. So let's just say the hearing officer sides with the school district. The hearing officer says, well, I agree with the school district. I render my decision for the school district. That decision is it. That is final. Unless the parent appeals to the state to say, I need you to review this. I felt the actions of the hearing officer were not appropriate. I felt the hearing officer didn't run this particular hearing correctly. Okay, but the decision is final. So unless you can show that what the hearing officer did was wrong, that there were some procedural violations done by the hearing officer, that's it. That is it. It is a legally bound decision. But you do have the right to try to appeal. An idea is silent as to the time period to which an appeal may be made to the state. Each state determines how long do you have to appeal a decision by a hearing officer. So if you're from Hofstra, you're from New York, and you're watching this, let me just tell you the New York rules. An appeal must be in writing and be received by the state within 40 calendar days after the parent and school district receive the decision by the impartial hearing officer. So if I, as a parent, get my decision, we get the decision in favor of the school district, and I want to appeal the decision, I feel that there were procedural violations in the procedures of what went down in our hearing, I have 40 calendar days to appeal. After that, you do not have the right to appeal. I have 40 calendar days to submit an appeal to New York State. And then New York State must make its ruling within 30 days of the receipt of the request for the review. So I have 40 days to create the appeal, to submit the appeal. And once the state receives that appeal, the state has to render its decision within 30 days. Okay, that's the appeal timeline. But again, one of the reasons why you want to consider not going to due process is because the decision by the hearing officer is legally binding. And so therefore you're rolling dice. Both sides are rolling dice because what the hearing officer says is final. And unless you can appeal on some procedural violation, the decision made by the hearing officer is legally binding. So to wrap up this lecture, we've been talking about dispute resolutions. We talked about IEP meetings, try to call for another IEP meetings. We talked about mediation and what's involved with mediation. And then we addressed due process hearings and the process of what occurs in the hearing and the decision of the impartial hearing officer being legally bound on whatever that situation is. So that ends this brief lecture on dispute resolutions, and it is now completed.